Parallels are being drawn between the Shiv Sena case in Maharashtra and what is happening in the Trinamool Congress in West Bengal. But experts who ThePrint spoke to said the two scenarios are different and the outcomes therefore could also vary. A look at the 2023 Supreme Court ruling in the Shiv Sena case also provides crucial clues as to how the TMC case may pan out. From the court saying that a split is no defense in disqualification proceedings and that this isn't just a game of numbers, to how the ECI may test who the real party is. This 2023 verdict could go against the rebel Trinamool MPs and MLAs and is likely to cast a shadow on their attempts to circumvent the anti-defection law. Hello, I'm Apoorva Mandhani, and in this video, I'm going to answer the question of whether the TMC crisis can go the Shiv Sena way. Now, a significant difference between the TMC and Shiv Sena is that there wasn't any merger in Shiv Sena's case, but in the TMC case, the rebel factions seem to be taking different routes instead of a singular united course of action. However, with regard to any attempts at claiming the party symbol or in disqualification proceedings arising out of the rebellion, the five-judge bench judgment of the Supreme Court from 2023 would apply to the Trinamool case. Among other things, the judgment had asserted that looking at the legislative majority is not enough for the faction claiming to be the real party, and that ECI must look to other tests in order to reach a conclusion on what or who should get the party symbol. In fact, the court observed that in cases such as Shiv Sena's case, it would be futile to assess which group enjoys a majority in the legislature. The other tests, it said, may include an evaluation of the majority in the organizational wings of the political party, an analysis of the provisions of the party constitution, or any other appropriate test. With regard to disqualification proceedings before the speaker as well, the court had observed that the speaker must not base their decision only on the basis of majority in the Legislative Assembly. Organizationally, beyond the Lok Sabha and the Assembly, Mamata Banerjee does seem to be in control. Therefore, it is this judgment which may come to her aid. Now, let's talk about disqualification first. Under the anti-defection law in the 10th schedule of the Constitution, voluntarily giving up membership of a party or voting against the whip can be treated as defection. Members indulging in such practices face disqualification, and there are 5 defenses to such disqualification, including the party's merger with another party. Prior to 2004, there was another defense to disqualification. It was a split in a party with no less than 1/3 of the legislators forming a faction and breaking away. Nobody faces disqualification in such a situation, neither the members who decide to merge nor those who stay behind with the original party. But an amendment notified in 2004 removed the split defense. The Supreme Court in the Shiv Sena case judgment had opined that the consequence of the deletion of the defense of split from the 10th schedule is that this defense is no longer available to members who face disqualification proceedings. It observed that when deciding disqualification proceedings, the speaker might be called upon to determine the real party when the party has split into 2 or more factions. This is because it is necessary to know which faction constitutes the original party to determine which party members have voluntarily given up membership of the political party under the 10th schedule and face a disqualification. But the court asserted that the speaker must not base their decision as to which group constitutes the political party on a blind appreciation of which group possesses a majority in the Legislative Assembly. It said that this is not a game of numbers but of something more. It said that the structure of leadership outside the Legislative Assembly is a consideration which is relevant to the determination of this issue. Now, while Apoorva Banerjee has consistently claimed to have support of over 2/3 of the MLAs elected on the Trinamool symbol, these observations of the court may play out if and when they face disqualification proceedings. Now, let's talk about the party symbol. Paragraph 15 of the Election Symbols Reservation and Allotment Order 1968 defines the power of the ECI in relation to splinter groups or rival sections of a recognized political party. Para 15 says that when the ECI is satisfied that there are rival sections or groups of a recognized political party, each of whom claims to be that party, the Commission may decide that one such rival section or group or none of such rival sections or groups is that recognized political party. ECI can do so after taking into account all the available facts and circumstances of the case and hearing the representatives of these sections or groups and other people who want to be heard. Now, the ECI decision shall be binding on all such rival sections or groups. In order to decide which group is entitled to the symbol, it is again necessary for the ECI to adjudicate which group is that political party or the real political party instead. The Supreme Court held in the 2023 case again that the substance of the ECI's decisions in such cases is the lifeblood of the recognized political party. In another landmark judgment on splits, this is an old judgment, this is Sadiq Ali versus Election Commission of India, the court had considered 3 tests for deciding such cases on who the real party is or who the symbol should go to. They were a test analyzing the provisions of the constitution of the party, a test assessing which of the two rival groups adhere to the aims and objects of the party as incorporated in its constitution, and third is a test evaluating which of the two rival groups enjoyed a majority in the legislature, that is, the houses of the parliament as well as the legislative assemblies of states and in the organizational wing of the party as well. So, the third test of majority has to come from all these factors. In the Sadiq Ali case, the court applied the test of majority, but the Supreme Court clarified in the Shiv Sena case in the 2023 judgment that this is not the only or even the primary test to be applied while determining disputes under paragraph 15. It said that ECI is free to apply a test suitable to a particular dispute. In the TMC case, the rebel MLAs may approach the ECI to replicate the Shiv Sena episode, but in that case, they would also have to show that they enjoy the majority with respect to support in the legislative as well as the organizational wing of the Trinamool. To support their case, they would not be able to show such a majority in the Lok Sabha at least, since the 20 MPs have written to the speaker that they're merging with another party. Therefore, experts say that with their merger claim, the Trinamool MPs may have completely washed their hands of the claim for ownership of the party and may have also spoiled the MLAs case for such ownership. So, the MLAs can still go to the ECI to claim ownership of the TMC if they are sure that the party has split and they have a majority on their side, but they will have to show that they have majority in the organizational wing of the party as well, not just in the number of MPs or MLAs, which may again prove to be difficult. Now, there is another question in this mix. It is of the leader of opposition in the West Bengal Assembly. The 2023 Supreme Court verdict also makes it clear that it is the political party and not the legislature party that appoints the whip and the leader of the party in the House. In the TMC's case, this issue is already playing out in the Calcutta High Court. Earlier this month, the West Bengal Assembly Speaker recognized expelled TMC leader Ritabrata Banerjee as the leader of opposition for the West Bengal Assembly. Banerjee had written to Assembly Speaker Ratindra Bose, staking claim to the post of LOP in the Assembly and claiming to have backing of 58 out of 80 TMC MLAs. Now, the development came days after TMC National General Secretary Abhishek Banerjee wrote to the Speaker to recognize Shobhandev Chattopadhyay as the LOP, citing practice and procedure and precedent. The Speaker's decision was challenged in the High Court by Chattopadhyay. For now, the Calcutta High Court has refused to stay the LOP appointment. It relied on Section 3 of the Bengal Legislative Assembly Members Emolument Act 1937, which has an explanation saying that the leader of opposition means that member of the West Bengal Legislative Assembly who is for the time being the leader in the state assembly of the party in opposition to the state government, having the greatest numerical strength in the said assembly. Relying on this explanation, the court said that the 58 members of the rebel faction secured greatest numerical strength by submitting their joint request and appearing before the speaker in person. So that is why, citing this, the High Court has for now refused to stay this appointment, but the petition remains pending in the High Court. I have written a more detailed story drawing a comparison between the Shiv Sena case and the TMC case. I'll be adding a link to it in the description of this video. This is a developing story, so we will keep an eye out on it. But for now, this is Apoorva Mandhani for ThePrint. For more such news and analysis, please check out our website and follow us on Twitter, Instagram and Facebook, and subscribe to our YouTube channel.